All right, good afternoon, everybody. Welcome to Socal LERA presentation, Preparing for Labor Relations in 2022, Major Issues Affecting Unions, Employers, and Employees. Today is Wednesday, November 17th, 2021, and the program is 90 minutes from 4:30 to 6 o'clock, and we are on Pacific Standard Time. We are recording, so for members, the program will be available for you. We want to encourage everybody to be a member, and we're compiling the benefits for our individual members. I want to first of all thank the National LERA hosts, Bernadette Tiemann and Emily Smith, who are the masterminds to putting on this whole program virtually. My name's Juan Gonzalez. I'm a semi-moderator. I'm an arbitrator and also Socal LERA Executive Director. We will get into introductions, but I do want to say that this program has really been put together by Joe Paller and Tom Lenz. They're on the executive board, and they really wanted to put a program together for our members to benefit them. Of course, members, it's no charge for them, and we want to thank you guys all for being members. So before I get into introductions, let me get into introductions. So we've got three speakers today. The first speaker we're going to have is Stephanie Cahn. Stephanie Cahn is a supervisory attorney at the National Labor Relations Board, Region 21 in downtown Los Angeles. She's a graduate of McGeorge School of Law and a career NLRB employee. She started her career as an attorney at Region 21 in 1997. You can do the math on that. In 2014, she began her current role as supervisory attorney. Before becoming a supervisor, she was counsel on multiple unfair labor practice trials and appeared before the federal district court in injunction litigation and subpoena enforcement proceedings. In her role as supervisor, she oversees 7 attorneys in their investigations of unfair labor practices and litigation. We're very happy to have Stephanie with us today. Second up is Joseph L. Paller. He's a lawyer representing labor unions and trust funds. He's a principal at the law firm of Gilbert and Sackman in Los Angeles. Joe is also chairman of the Personnel Commission of the LA Unified School District that provides civil service protections for 38,000 classified employees in the nation's second largest school district. I imagine New York is the largest. Is that right, Joe? Thank you. Joe teaches classes at Labor and Employment Law at USC Gould School of Law and LA Trade Tech College. Third up today is Tom A. Lenz. Thomas Lenz is a partner at Atkinson, Andelson, Loya, Ruud, and Romo law firm and is based in Pasadena. He represents employers across California and elsewhere on labor and employment law issues. He began his career also at the NLRB Region 21. It's a family affair in Los Angeles. In addition to his law practice, Tom teaches at USC Gould School of Law and serves labor and employment law section. I cut that off. Serves the labor and employment law section of California Lawyers Association as an advisor after serving as chair of the section. He's a Socal LERA board member and past president when we were OC LERA. He's a graduate of Marquette University and Louisiana State University Law Center. I want to recognize and thank the panel members for giving me their amended bios so that we don't eat up too much time. I want to remind everybody that there's a link in the chat with our link to our event page. On the event page, you could scroll down and look at the bios and more extensive information on the panelists. There also listed are the handouts that each participant is going to be using on the event page. You have the link in the chat. We want to encourage questions from the panel to each other and also from the participants. If you have questions, put them in the chat. And don't feel you've got to pen the perfect question. Just ask to discuss more on one topic or another. Tell tell me more about vaccination mandates or voting or anything like that. So we've seen in the past, people just don't feel too comfortable asking questions, but I know the panel wants to interact as best as they can with the group and make sure that they're discussing topics that are important to them. Please be sure to turn off your audio. For MCLE credits at the end of the program, we'll ask you to put in your name, your email, and your bar number so that we can send you a certificate. With that said, I hope I covered everything. I wanted to hand it over to our first speaker, Stephanie Cahn.
Great, thank you, Jimmy. Thanks everyone for taking time out of your evening to join us. I'm going to go ahead and share my screen, and hopefully everyone can see that. Let me know if you cannot. I'm going to be going over some of the GC memos that have come out recently. Now, the change in administration in January of 2021 brought new leadership to the board, which currently has a Democratic majority and a new general counsel, a GC. The GC basically determines which cases the regions pursue and prosecute, and therefore which cases are considered by the board. The GC's office issues periodic memoranda to the regions and to the public to advise of the positions it is taking or intends to take on various issues. As I mentioned, the GC memoranda, which I'll be talking about, provides policy guidance to the regions and the public. So this all started back on January 25th of this year, when an acting GC was named, that was Peter Sangor, who in March of this year issued one of these GC memos, suggesting the direction the GC's office would be taking in regards to protected concerted activity. And that is GC 2103. Let me see, there we go. And that's this memorandum reiterates that Section 7 of the NLRA gives employees the right not only to assist or join a labor union, but also to engage in concerted activities for the purpose of collective bargaining or other mutual aid or protection. Two important points to take away from this memo are: one, the reading of mutual aid or protection is broadened to apply to today's workplace, and it includes political and social justice advocacy that has a direct nexus to employees' interests as employees. It no longer needs to be connected to a specific workplace concern. So this is things like Black Lives Matters. Two, reiterating that a group of employees banding together or a single employee seeking to initiate or induce group action, including contemplation of group activity, whether realized or not, is considered inherently concerted. So examples have traditionally included discussion of wages among employees, changes in work schedules, and job security. The GC plans to consider discussion of workplace health and safety and racial discrimination as potentially inherently concerted. I don't know if Tom or Joe have anything they'd like to add?
Yeah, I would just, if I can, I don't mean to step on Tom's toes, but I would say it's great to see that the new general counsels recognize the obvious connection that exists between workplace issues and social justice and politics, for that matter. They all have a direct connection to the workplace, and concerted activity related to political and social justice issues have long been just as deserving of protection from employer coercion as have the more traditional rights to organize a union, for example. And, you know, I think this is all kind of seeing these kinds of approaches as is kind of a reflection on Joe Biden's campaign promise that he would, I think the words were, be the most pro-union president you've ever seen. That was Biden's promise, and he's in his first 9 months of office, he's kind of living up to that claim. And speaking as an advocate for labor unions, I've seen what I think is the most challenging, I'll use the word challenging, NLRB in my lifetime, the Trump NLRB, replaced by a truly outstanding, forward-thinking general counsel and excellent appointments to the NLRB. And it just shows that there are so many big changes that are in store for labor management in 2022 and beyond. This is just one example of how this new recognition of the importance of political and social issues in the workplace. So this is another one that I know unions are embracing.
I'll just add very quickly that this was a sign right off the bat that it's a new day for labor law, for labor relations. This memo indicated that the board is going to be looking at things in a more expansive way with protection for employees. And in the wake of all the social issues that we've seen, it's a reminder that there is legal protection. It's something that I think management lawyers need to remind their clients that, you might think something is extraneous and unrelated, but it may well have legal protection. And in the wake of a case like Allstate, which I thought was a terrible decision in terms of what is protected activity, it's going to remind people that discussion of wages, even if it is what some people might consider griping, may well have protection under the law. I'll stop there.
Great, thanks. That was the only GC memo issued by the acting general counsel, as Jennifer Abruzzo, a longtime NLRB employee, was sworn in on July 22nd of 2021. Then shortly thereafter, she issued a memo identifying the issues she wanted submitted to the Division of Advice at the NLRB. That's the division that provides guidance to the regions on significant legal and policy issues. So that was GC 2104, which are the mandatory submissions to advice. So this was a lengthy memo, and it was divided into 3 sections that identify areas that if they arise in cases being investigated in the regions, that the GC wants to review them. So I'll briefly go over the highlights of each section and the areas that she would like to, she's kind of looking at during her term. So the first section concerns cases and subject matter areas where in the past several years, the board overruled legal precedent. So this includes items such as workplace employee handbook rules, particularly those concerning confidentiality, non-disparagement, social media, civility, offensive language, and cameras. An application of otherwise lawful workplace rules used to restrict Section 7 rights. Confidentiality provisions and separation agreements. What constitutes protected concerted activity, kind of echoing back to the memo that the acting GC issue that we just talked about. And she also pointed out this could include using an employer's email system for workplace communications. Right line and the GC's burden regarding motivation, adverse action, remedial issues, union access, dues checkoff and BEC rights, employee status, especially independent contractors, board jurisdiction over religious institutes, employer duty recognize and bargain, things like unilateral changes, anticipatory withdrawal of recognition, firm successorship, information requests, and inability to pay, implementation of last, best, and final offers, and deferrals to arbitration. That's all just in the first section. In the second section of this memo, it involves initiatives in areas not necessarily the subject of recent board's decision, but ones that the GC would like to examine. And this includes areas such as finding classification of employees as independent contractors unlawful and individuals working in rehabilitative settings, wine garden rights in non-union settings, the National Mediation Board versus the NLRB jurisdiction, regarding certain airport workers, employer duty to recognize and bargain, focusing on surface bargaining, refusal to provide information related to relocation or other decision, midterm withdrawals of recognition after the 3rd year of a collective bargaining agreement, refusal to bargain, recognize based on card majority, permanent replacement of economic strikers, intermittent strikes, secondary picketing, remedies and compliance issues, and employer interference with Section 7 rights. So there's quite a few in that. These are just actually the highlights And then the third section of this memo being submitted to the GC cover matters traditionally submitted to advice. And it's including, but these aren't all of them, as I've mentioned before, harmonizing the act with local, state, or other federal statutes, or overlapping jurisdiction with other federal agencies, injunction litigation under Section 10J of the Act, and contempt of 10J orders, complex subpoena issues, and EJA claims. So, Tom and Joe?
Tom?
Yeah, I can't say I'm too surprised by the scope of issues that the general counsel wants to focus on. There certainly were a lot of different views expressed in the prior administration, and the decisions that the board came out with. I think that what is being proposed in the way of re-examination is somewhat politically typical in the sense that from one administration to another, you may see fluctuations, but there are some fundamental threads here. The nature of protection, who is protected, and what will be the repercussions for violating the act. I think that we're really in a new day in terms of the scope of who is going to be regulated and what the amount of protection will be, what the remedies will be. But this is really setting the table. And as a management advocate, I look at this as a sign to tell my clients, various employers across California and elsewhere, that you need to watch out. These are issues that are being focused on. Do you want to be a test case, or do you want to do things that are going to keep you out of legal hot water? And I think different employers have different perspectives on that, and how they want to navigate through these issues. But I think it's something that even non-union employers may not be aware of, and I think they need to be advised of the potential pitfalls.
Yeah, and I would just add there that you're looking at this list and reading some of the commentaries that have been coming out. Some authors have said that this is just simply an effort to reverse the positions that and initiatives that were taken by the Trump board and the former general counsel, and just maybe to build a little bit on the rights and protections that were that came out of the Obama NLRB. But I don't see it that way. I think this is an attempt to reinvent the board a bit and to move beyond what may necessarily be traditional positions that have been taken by boards in years past, and perhaps to blaze some new trails and getting the board involved in areas it hasn't been involved before, and also to try and seek to revitalize the board's meaningfulness within today's society and today's workplace. And all this means, as Tom alluded to, that there are going to be new opportunities for labor and new challenges for management in their approach to how they treat their employees and how unions represent employees. So it's all really exciting stuff, and it's a great PowerPoint.
Great, thanks. So moving on, after this memo, which was the first one by the GC, other ones were issued in quick succession, so we'll go over those. The next one is GC 2105, utilization of 10J proceedings. So in this memo, the GC stated that she intends to aggressively seek 10J injunctive relief and wants a robust 10J program. Just for those who may not know, Section 10J of the Act authorizes the board to seek injunctive relief in U.S. District Court in situations where, due to the passage of time, the normal adjudicative process of the board will be insufficient to remedy the alleged violations. I think last year there were not that many 10Js that the board authorized, and so she wants to change that. In this memo, the GC knows that she's seeking 10J relief in cases primarily involving discharges during a union organizing campaign, violations during a campaign that might justify a GISL bargaining order, violations that occur during the period following certification of first contracts, withdrawals of recognition from incumbent unions, and successors' refusal to bargain and/or refusal to hire. Joe or Tom, do you have any comments on that?
I'm not
Well, yeah, I
surprised.
mean, from the union standpoint, perhaps one of the most powerful weapons that the NLRB has at its disposal is the Section 10J relief. I see this not so much as a new initiative, but potentially a new focus on 10J activity. Section 10J, as Stephanie says, allows the agency to go into court at a very, very early stage of perhaps just after an unfair labor practice charge was filed, and to seek an injunction from the district court that would stop unlawful activity before it gets out of control and puts the parties in a position where it's impossible to return to the status quo. I'm very excited about that, but the whole key to success with a 10J program is the ability to move quickly. And that takes a great dedication by the staff and resources by the board itself. So we're all excited to see this. I have my fingers crossed that it's going to be successful. Certainly, it's something that the labor movement is looking forward to.
It's definitely going to put some teeth into the board's enforcement of this expanded notion of rights that I think is coming, and the remedies that are likely to flow. I think that while the past administration would say that they pursued 10J as well, it certainly was not with the vigor that we saw, say, under the Obama administration. I think we'll see as much enforcement, if not more, in this administration. Noting, as Joe said, that President Biden has indicated his strong support for unions.
Right, thanks. So moving on to the next slide, the next memo that the GC issued is seeking full remedies. So now this is going to, GC is looking about making what's called full remedies, because the board's traditional remedy, probably most of you know, consists of posting a notice, usually at the employer's facility, and then for cases involving unlawful layoffs or terminations, the remedy requires employees be reinstated to their previous positions or substantially equivalent, and then be made whole for loss of earnings and benefits. And then that's it. So in this memo, the GC stated her intention to consider the full breadth of remedies available, both ones that are established and new or alternative ones, to make sure that these discriminatees, the people who are being laid off or terminated unlawfully, are afforded the full relief under the Act for losses incurred as a result of an unlawful discharge. So here she's focusing on the types of remedies that regions should be requesting from the board in appropriate cases. So these will be set forth in complaints. The memo contains numerous possible remedies regions should be seeking, and I'm going to go over a couple of them. The first one is consequential damages for economic loss, including healthcare expenses, compensation for credit card late fees, or loss of a home or a car. And after this came out in the memo, just recently on November 10th, in a case, the board invited parties to actually submit briefs addressing whether the board should expand its traditional make whole remedy for employees who are discharged, laid off, or otherwise discriminated against to more fully account for their actual economic losses. So the board will consider whether to establish a practice of awarding a fuller accounting of consequential damages in addition to loss of earnings and benefits to employees who suffer unfair labor practices. So I think those briefs are due at the end of December 27th. So maybe shortly thereafter, we'll know what the board decides. Some of the other remedies she's advocating in this memo, make whole remedies to compensate employees for losses sustained as a result of an employer's refusal to bargain, bargaining schedules and submission of periodic progress reports to the region, extension of a certification year, front pay in lieu of reinstatement, liquidated back pay, notice readings and publications of the notice, training of employees, supervisors, and managers on compliance with the Act, GISL bargaining orders, having union have access to employee contact information, reimbursement of organizing expenses, broad cease and desist orders, and other remedies that may be appropriate in a particular case, which means I guess we can come up with our own to fit a particular situation. Joe and Tom?
Yeah, I think that, there are reasonable minds that will differ on what make whole means. And we're at a moment where I think there's interest in invigorating the processes at the board, invigorating awareness of what the board can provide, and certainly this scope of remedies, which I would imagine will be a checklist the regions will be running through as they look at cases. It's going to be, I think, a call for creativity to look at a situation and see really how was somebody harmed. And I think it really ups the ante for employers. I'll be explaining to my clients that whether or not the PRO Act passes in Congress, the agency is going to be, I think, putting creative minds to the test, not so much trying to chill things, but trying to really add some life to what this law stands for. So I think the exposure that employers are going to face is significant. And I'm imagining there's going to be a lot more litigation over what make whole means, even if we're basing it on the statute as it's written right now. So it's going to be interesting times, and it make it harder to settle cases.
I can't agree more with what Tom said. I think it's going to be an adjustment period, but really what's going on here is that is a reform effort. The NLRB historically has lagged behind other agencies and courts in the kinds of remedies that it will award to employees, unions in light of unfair labor practice charges. Talking now about expanding the use of front pay, well, that would just be bringing the National Labor Relations Board into step with almost every state and federal court in the country. But it's something that really is long overdue. And I'm not so sure that the kinds of remedies that are being talked about are revolutionary in any sense. Most employers have had to deal with these kinds of remedies, and in fact, more serious remedies in dealing with state and federal courts in wrongful discharge, discrimination, and different type of tort claims. But getting front pay in lieu of reinstatement can be extraordinarily valuable in many situations. Consequential damages are deserved in every situation in which an employee has faced unlawful discharge as a result of the violation of the act. So I really welcome these, but I also think that these kinds of remedies are long overdue.
Great, thanks. The next memo, GC 2107, again addressing remedies, but this time full remedies in settlement agreements. So the GC followed up with this, and she further reiterates the need for these types of remedies beyond back pay to be pled in complaints and pursued by the regions in both informal and formal settlement agreements. So this memo identifies actually more potential remedies to be considered, including both new and those supported by board law. So for example, compensation for penalties incurred by early withdrawal from retirement funds to cover living expenses after having been unlawfully terminated. Compensation for damages caused to an employee's credit rating. Compensation for having to liquidate a savings or investment account to cover living expenses. Fees or expenses to obtain or renew a security clearance, certification, or professional license denied or lost as a result of an unfair labor practice. Moving expenses, where a discriminatee must move to obtain comparable employment or return to accept an offer of reinstatement. Legal expenses incurred in connection with the employer's unlawful conduct. Letters of apology, concurrent with unconditional offers of reinstatement. I can just say, as anecdotally, over the years, I've encountered a lot of people who've actually wanted letters of apology. So I think this is actually meaningful to many people. Other remedies, sponsorship of work authorizations and other remedies for undocumented workers, expanded use of security provisions to facilitate collection proceedings if necessary, exclusions of non-admissions clause and the inclusion of admissions clauses for repeat violators, innovative provisions regarding the dissemination of the notice, such as texting. And then in this memo, the GC also reinstated the inclusion of default language in settlement agreements that provides for expedited issuance of a board order in the event of non-compliance with the settlement without the need for further litigation of the allegations. Joe or Tom, do you have any comments on that?
Sure, I'll go first. I think that this is going to, really play into the sort of effectuation arguments that we've heard over the years with the agency. Does a settlement, does a resolution effectuate the act? Does it make sense to consider a case resolved? Whether it's board or non-board, and I think that the agency is going to take a more aggressive stand. So it's going to be, I think, difficult to just write up some, quick agreement and pay somebody something and expect them to go away and expect the board to accept that. The board is going to want public policy to be fulfilled in its vision of employee rights. So it may make things harder to settle. And again, this may prompt more litigation, but I think this is a sort of fluctuation in policy that we've seen between administrations. I think we saw tougher standards during the Obama administration in getting settlement agreements approved. So yeah, I think it could pose an obstacle in some cases, but hopefully parties will be mindful and work together to get cases resolved.
I think this for me was a very unexpected development and one that's truly welcome. And I share Tom's concern about the fact that sometimes the settlement agreements that are entered into by the parties don't in fact advance the purposes of the act, even when it's quite clear that unfair conduct has taken place. Basically, in a typical case, for example, of an unlawful discharge, sometimes the employee is so desperate that they'll accept a small amount of money in return for a settlement of an unfair labor practice charge, just because they need the money. And the board has traditionally, I don't want to say look the other way, but consider justice to have been done because the individual discriminatee has accepted a settlement. I think this is the new initiative, as surprising as it is to me, is very, very welcome, because the board is going to be taking a harder look at kind of quick cash settlements and whether or not that just simply gets rid of an unfair labor practice without any remedial function, or whether it in fact is something that ought to be approved. So I like it. I'm hopeful it'll be fairly new ground, I think, but it's something that I think most unions are going to welcome.
Great. I'm going to move on to the next memo that she issued is GC 2108, and that is the statutory rights of players at academic institutions, commonly referred to as student athletes. So this memo reinstated a prior GC memo from 1701, and the first numbers referred to the year it issued, so that was from 2017. That was regarding the statutory rights of private university faculty and/or students under the NLRA. So specifically, that prior memo addressed the decision in Northwestern University from 2015, and that was the case where the board declined to exercise jurisdiction over a representation petition filed by a union to represent scholarship football players. So in this memo, the GC states that her position is that certain players at academic institutions are employees under the Act, and that misclassifying them as mere student athletes and leading them to believe that they don't have statutory protections is a violation of 8A1 of the Act. And we're going to actually get to see this play out, as last week there was a charge filed in our Indianapolis office by not an individual, but the College Basketball Players Association against the NCAA, alleging just this, an 8A1 violation by classifying college athletes as student athletes. So we will see, how this plays out and what happens. I will move on to 2201, which is the next memo issued. And that was ensuring rights and remedies for immigrant workers under the NLRA. So in this memo, the GC reiterated the board's position that the Act's statutory protections are afforded to all covered workers, regardless of their immigration status, and stated her intention to zealously guard the rights of immigrant workers to be free of immigration-related intimidation tactics that seek to silence employees, denigrate their right to act together to seek improved wages and working conditions, and thwart their willingness to report statutory violations. So specifically, the agency will seek immigration relief for witnesses and victims of unfair labor practices, certify petitions for U and T visas, respond to coercive tactics directed against immigrant workers, investigate and litigate practices to effectuate the Act for immigrant workers, particularly with regards to status, name, address, seeking appropriate remedies for immigrant worker retaliation, preventing abuses during litigation regarding immigration status, engaging in interagency collaboration, including refraining from enforcement activities at a workplace currently under investigation by the NLRB, and training board agents on immigration issues and increasing community outreach. I don't know if Tom or Joe want to comment on that.
Yeah, I would comment really quickly on this, is that, there's been, since the Supreme Court's decision in Hoffman Plastics many years ago, it's been difficult in geographical areas like Southern California, more difficult than it should be to organize immigrant workers, even those who are documented. The concern is that the board will not do anything to protect workers who are engaged in concerted activity to try and better conditions in the workplace. They won't help. If someone's discharged, they can't reinstate them to employment under Hoffman Plastics in circumstances where they're not documented. So why even bother? Nonetheless, Southern California is noteworthy in the extent of organization of undocumented workers. But I think it's time for the board to step up and come up with different remedies that will in fact make the NLRB's involvement in litigation under the National Labor Relations Act, that will make that more meaningful for the individuals who stand to lose the most from confronting their employers and demanding unionization. So this is welcome.
I agree with Joe. I worked at Region 21 when Hoffman Plastics was pending, and I helped a little bit with that investigation, never knowing that charge would end up going to the Supreme Court. And it astounds me the ways in which that case was spun into different arguments and efforts to deprive people of rights and remedies. And as a management lawyer, I want the rules to be applied equally. And I think that if people are going to hire the undocumented, they're taking a risk, and there are certain issues that tie into that. But as far as NLRB's role, I look back on my days as an information officer and having people come in and they were afraid even to ask questions because they weren't sure if they were going to get sent to immigration if they talked to me as a federal agent. I mean, that was shocking to me. So as a management lawyer, I want my clients to understand that, if you have people who are undocumented working for you, you need to comply with the law. But insofar as they raise issues involving their working conditions, or they try to form and join a union, they've got rights like other people do, other employees under the Act. And so this is important, and hopefully it will enable people to, have equal protection under this law, which is supposed to provide rights for all employees in the private sector, except as specifically excluded. So, I think that arguments on these points and defenses on these points are so disfavored by the agency and by courts. But these issues have been so politicized that it's important that the agency speak out on this to ensure that people have rights or understand that they have protections under this law.
Great, and now I'll cover our last memo, which is an OM memo, operations memoranda. So sometimes the general counsel's office issues these types of memoranda that give direction in case handling or administrative matters. So this one issued on November 10th. And it is responding to inquiries regarding the bargaining obligations under the Department of Labor's Emergency Temporary Standard, that's ETS, to protect workers from the coronavirus. So this memo provides NLRB information officers, those who answer inquiries from the public, with a framework for answering questions that might arise about ETS, and provides insight into the GC's views on ETS and any bargaining obligations that may arise. So prior to the background here, on November 5th, the Department of Labor's OSHA announced that the ETS from coronavirus to protect workers from coronavirus that covers employers with 100 or more employees. So the ETS requires covered employers to develop, implement, and enforce a mandatory COVID-19 vaccination policy unless they adopt a policy requiring employees to choose to either be vaccinated or undergo regular COVID-19 testing and wear face covering at work. Now, the GC's bargaining position is that, the GC's position is that covered employers would have decisional bargaining obligations regarding aspects of the ETS that affect terms and conditions of employment to the extent that the ETS provides them with choices or discretion regarding implementation. To the extent that the ETS does not give covered employers discretion, the employer is obligated to bargain about the effects. And just as a note, the status of the ETS actually remains uncertain because on November 12th, the U.S. Court of Appeals for the Fifth Circuit ordered a continuation of the Fifth Circuit's stay of the ETS. So it's not in effect right now, but at least this OM memorandum was issued ultimately to offer guidance to parties, practitioners, and the public as needed. Now, all of these memos can be found on our website, and that's at www.nlrb.gov. So I will now turn it over to Joe.
Okay, but before I get started, I know Tom may want to comment about this, but I will say that the COVID memo, if we could call it that, is really welcome. I mean, one of the areas in which I think the prior administration failed labor and management was by their complete silence, and it was almost complete silence in the face of the COVID epidemic on issues such as bargaining obligations of employers and bargaining duties of unions as well. So this is welcome, and I think it has much broader implications than just the federal emergency temporary standard. Reading the memo, it becomes quite clear that there are bargaining obligations that employers have, even when there is a state or federal mandate that employees be vaccinated. Even then, there's a bargaining obligation. And I think what ultimately will come down will be something along the lines of what the California Public Employee Relations Board did back in July in the Regents of University of California case. They concluded that the employer need not bargain about the decision to adopt a mandatory vaccination policy. In this case, for the flu, they weren't even discussing COVID, but it's applicable to COVID as well. That much like the General Counsel's memorandum, the PERB concluded there's no obligation to bargain about the decision to adopt a mandatory vaccination policy, but that the employer has an obligation to bargain about the implementation and the effects of the decision. And that means what's the vaccination date? When it is going to be implemented? What are the contents of the notice to employees regarding the vaccination mandate. What are the exemptions? We know that there are going to be exemptions under the Equal Employment Opportunities Law for disabilities, medical issues, and religious, sincerely held religious beliefs. So how's that going to be handled? And finally, and the one that we seem to see most in unions, are what are the disciplinary consequences if an employer violates the employer mandate to vaccinate? Is the employee going to be fired? Is the employee going to be put on a suspension or perhaps on a leave of absence? How's that going to be handled? Well, all those are issues and very important issues that an employer is going to have a duty to bargain with the union about, and a union is going to have some duty to represent their employees in bargaining with the employer. Tom, I don't know if you had any thoughts on that.
I do, but I'll wait till I get to my slides.
Okay, great. All right, then maybe it's time for me to get to talk about my slides. You know, in the interest of time, I'm going to kind of blast through the 12 slides. Let me see if I can get them up on the screen right now. The slides themselves, while I'm hunting to do that, the slides themselves are really pretty detailed. Where are they down here? Here we go. Can you see them? Let me know. Good, I see some thumbs up. Yeah, the slides are pretty detailed. I'm going to go through them quickly, but I put in that level of detail so you can take a look at them later on and have some idea of some aspects of the different things that I'm going to talk about that really aren't, that I'm really not able to talk about in the interest of time. Let me go to the second slide here. Labor, you know, we've heard from Stephanie Cahn about the important issues that the General Counsel and the National Labor Relations Board will be considering recently. And of course, it's not everything, but there are many additional issues that labor unions are going to want to raise with the board if an opportunity develops. And I'm going to talk about 4 of those issues. Some are kind of a reach, but they're all priorities for unions, and that unions are talking about trying to find the cases that will give them the opportunity to place these issues before the General Counsel and ultimately the board. The first one that I want to talk about is the effort to end the double standard that's applicable to no solicitation and no distribution rules. Now, under board law, for decades, it's been the case that employers are currently permitted to maintain and enforce policies that will forbid employees from communicating with each other during work time about unionization. And by the same token, an employer can have a no distribution policy that prevents the distribution of literature in work areas and during work time. And so in other words, the employees are basically confined to talking about the union in the parking lot or a break room, but not anytime during working hours. Meanwhile, in the threat of a union campaign, many employers will conduct what's called captive audience meetings during work time. And during that work time, they'll conduct these meetings. Employees will be compelled to attend. And they will also distribute literature during work time in work areas, the same kind of conduct that the employer is free to prohibit unions from doing. Well, one of the initiatives that labor is going to have is to trying to get the NLRB to recognize that it should be a ULP or objectionable conduct if an employer follows that double standard and conducts anti-union captive audience meetings on work time while forbidding employees from communicating about the union in any other workplace setting. So that's one. Another one is closely related to that, and that is an initiative to stop captive audience meetings, or at least to try and get them under some kind of control. Captive audience meetings, let's face it, they're inherently coercive, since employees realistically can't refuse to attend. They have to go. You can't just say, I'm not going to go there, I'm going to stay at work. In many cases, they can't perform work unless the other employees are present. So it's never, ever been voluntary. And then on top of that, there's always a grant of a benefit, because employees get paid for sitting and listening and perhaps talking while without having to perform their regular work duties. So there's a benefit, and almost any employee will prefer to sit down than to stand at a punch press for 8 hours, to sit down and listen to some diatribe about the evils of unionization, rather than actually having to perform what may be heavy manual duties. So I probably should stop and ask Tom if he had any comment on that.
I think it's interesting, Joe, and I'll leave it there.
Okay.
I think that what happens on work time, what happens on an employer's work premises, from a management perspective, that's going to be within the rights and control of the employer. But I certainly share concern about an employer suggesting that there will be some negative repercussion, or doing something to overtly threaten or intimidate the workers. So I think that I'll be interested to hear these arguments, but I know my clients won't be happy if they advance.
Okay, great. Thanks, Tom. Let's see what else we got. We had a couple more things. This is kind of a busy slide, but what we're seeing more and more, particularly with COVID, is that employees find themselves dispersed in a wide variety of locations, including their homes where they're performing work. And that's something that's new with COVID, but it's really not new in terms of the way business operates now. You have people that work as cable installers, people that work as servicing residences, home healthcare workers, and they often don't have any means of identifying or communicating with other employees. So one of the thoughts is that that I think is going to be pursued will be an effort to try and to have the board compel employers to give a pre-petition list of employees to an organizing union where lots of the employees, in fact, work alone or in small groups. And that would enable employees to communicate effectively with one another about matters of mutual concern, and give the opportunity for the union to communicate with them as well. So that's another initiative. Let me go to one more, and this is one that I know will probably cause a little consternation on the part of some of the regional folks at the NLRB regional offices, and that is to come to the realization that in many cases, employer workplaces are not, in fact, neutral locations for voting. And the fact is the employer controls access. The employer has people watching people going to and from the polling booth and leaving the work site. And there's a natural intimidation factor in there that's kind of inherent in having voting in the workplace. I think union will be looking for the opportunity to say, look, maybe not in every instance, but in some instance, the union should have a right to object to an election at the employer's premises, since on the basis that employer property is not a neutral site. And that would occur in circumstances where, for example, it'd be possible to substitute mail balloting, which is often done, generally with the party's consent, or potentially to have if there's a neutral offsite location, to conduct the balloting at that location. It would have to be conveniently close to work. We've done this in the past, sometimes with little success, sometimes with great success, and the board has in fact ordered it in the past, but I think the unions would like to see more of that. I don't know, Tom or Stephanie, if you had any comment on that.
Well, mail balloting has become the norm during COVID, and I have to wonder whether the paranoia that employers have had about it over the years has dissipated. I've certainly, had clients who, would say that they won an election in the mail ballot era. So, yeah, maybe this is something that warrants more consideration. I know, in my days at the region, we had circumstances where we did elections off-site, typically because an employer wasn't cooperating with the process. But yeah, perhaps more difficulty to get the job done, but worth considering.
Stephanie, any comment?
Yeah, I think from what I heard, many years ago, employers did not want the elections held on their site. So they were held at, I guess, a true neutral location. And then, I think employers learned that, hey, it was actually beneficial hold the election on their site. And so that's, you know, kind of where it has been more recently. So that probably is how it, you know, gives rise to one of these union initiatives here.
Very interesting. It's very, very interesting area. And I'm going to move ahead a little bit because there's something else that may be coming up. This slide here is highlights potential litigation that might give the NLRB additional civil penalty power. And that is, we have the proposed Build Back Better Act. That's the Budget Reconciliation Act that's been pending before Congress for months and months and months. This was going to be the companion bill to the infrastructure bill. And it's still kicking around, but something is still in the legislation. They've carved a lot of pieces out, but this is still in the legislation. And that is a new provision that would, if passed in its current form, allow the NLRB to assess penalties of up to $100,000 for unfair labor practices, and also to directly fine corporate officers and directors, corporation directors, in the event that certain unfair labor practices have taken place. It's really interesting. We're going to have to keep an eye on the bill to see what happens with it. One of the other issues that I don't think is controversial, but has gotten absolutely no press attention at all, it would be to authorize an expenditure of $5 million for implementation of systems to conduct electronic voting in NLRB elections. And that's really welcome. I mean, many agencies have embraced the idea of electronic voting, as have many state and federal governments. The idea is people would be able to vote from their phone or vote from a computer or a tablet, so there'd be no necessity for a mail ballot. And it would be something that employees could do from the privacy of their own car or their own home with minimal, without requiring a trip to the post office or trip down that long haul to vote at the employer's work site. So that may be coming, whatever happens with the section on civil penalty power. Any comments on that? Okay, well then let me move on. I've got a few more slides on California laws. And I think I just wanted to highlight some of the things that are coming in 2022. That I think are going to make some further changes to the landscape that's for California private sector employers. I'm going to save one slide at the end to discuss two new public sector initiatives that have been passed by the state. The first one, this slide 7, is not. It's a law that was actually passed in 2021 and is effective in 2021. So it's already effective now. The other laws I'm going to talk about are all effective in 2022, although some of them are just changes to current laws. This is a short-term law. This COVID-19 temporary recall rights. This law is going to be in effect until 2025. It expires on December 31st, 2024. And what it does is it requires employees in a specified industries to recall employees who were laid off because of the pandemic. They have to call them back to work, and they have to do so in seniority order, and they have to give people a meaningful opportunity to decide whether they in fact want to go back to their current or to the employer they had before the pandemic. And this is applicable throughout the hospitality industry, in hotels, and as well as convention centers, certain parts of airports, and many other large industries. And it bleeds over to different categories of employment, like the people that are in the parking lots at these centers. And it really does affect a very large percentage, I shouldn't say a large percentage of the work, but it has workforce, but it has significant ramifications for the industries that were most affected by COVID-19. The ones that were forced to shut down or lost a huge amount of work, like convention centers and hotels. This is a very important law, and it is now in effect. Another law, I should mention the second slide about it talks about the remedies on this, and it's really kind of astonishing. You know, we had Stephanie made a great presentation about the General Counsel's aims and trying to strengthen the remedies that are available where the unfair labor practices are found. Well, these are the remedies that are available for an employer that violates this simple recall right. It doesn't seem like they would, that they might be this great, but the legislature thought they should be. It provides for reinstatement. It provides for back pay. It provides for front pay for the period of time in the future when the employee will be unable to work for that employer or another employer. It calls for payment of the value of the benefits the laid off employee would have received under the employer's benefit plans. It provides civil penalties of $100 for each employee whose rights are violated, an additional sum payable as liquidated damages of $500 for each day that these rights were violated. And then, of course, it allows the labor commissioner to seek an injunction and civil penalties. Tom, have you had any experience with that or any comments about it?
No comments right now.
Okay, then let me just jump over to the next slide.
Joe,
Yeah,
Joe,
sorry.
before you go on, I see there's a question in the chat. Does the recall law preempt CBA provisions?
Say that again?
Does the recall law preempt CBA provisions?
Oh, I think that's exactly what Tom is going to be arguing. That the collective bargaining, the opposite, that the collective bargaining agreement would contains language that may trump, sorry to use the term, trump anything that might be in the state law. On the other hand, I would argue that this law establishes a minimum labor standard applicable to this, that the state has promulgated, that's applicable to private sector employers in terms of and whether or not they're unionized. These rights would be available to anyone who's unionized or not unionized. Ultimately, this is an issue that I think will probably be raised. Some of these industries are heavily unionized. They'll probably be raised either before arbitrators or in court. So I think we're going to get some more definitive answers on that. And you might say, well, the whole thing's going to expire at the end of 2024. People just work these things out. I don't think that's going to happen. I think that we're going to be seeing some litigation about this. And I should mention that I really haven't looked to see if any litigation has been filed about this yet. I don't know if the labor commissioner has filed any cases on it, but I think that some are probably going to be forthcoming, and this will be one of the central issues in the case.
I agree, it'll be litigated.
All right, the next one is surprisingly, I don't want to use the word draconian, but I'm going to use the word draconian. Basically, wage theft is now grand theft. That means if you're wage theft, which means that the employer didn't pay wages knowingly to an employee that performed work, that's now punishable as a felony. And we're not talking about wage theft of $10,000 or more. We're talking about wage theft in excess of $950 for a single employee, or $2,350 for more than one employee. And what is felony grand theft? Well, it's something that's punishable by imprisonment for up to 3 years, as well as fines and penalties. This goes into effect January 1st. There's also a provision that wraps independent contractors into this. So even though someone is not really a wage earning employee, if the hirer of that independent contractor stiffs the independent contractor, that hiring entity is going to be considered to be a potential felon. So anyway, that's coming into effect in 2022. Tom's not saying a word. Good. I got a couple more slides. This is another really busy slide. In fact, it focuses over 2 pages. So I'm not going to go into all of it. We currently have laws that limit the ability of employers to require employees to agree not to disclose certain kinds of workplace acts and not to disparage the employer. Many of those policies run afoul of the National Labor Relations Act to the extent that they might prevent employees from communicating with the media or with each other about potential common interest issues such as harassment in the workplace. Well, California had a law that severely restricted the use of these kinds of non-disclosure, non-disparagement agreements in situations where, let's say, a sexual harassment claim might be settled. And it was all because of the Me Too movement, which exposed the fact that employers were, in some cases, routinely settling sexual harassment cases by paying money and then requiring the employees not to disclose any of the facts that had occurred, so that it just meant that someone else would be the next victim of harassment. Okay, well, in 2022, the law is going to be affected to go way beyond sexual harassment. It would make invalid any kind of workplace policies that might prohibit disclosure of factual information about any kind of harassment or discrimination that might violate the Fair Employment and Housing Act, the state law. It's no longer limited to sexual harassment. And this is also interesting because it doesn't just have to do with settlements. It also has to do with employer policies, which might say something to the effect that an employer, that employees may not disparage employees, the employer, and might even call within its sweep issues involving discrimination or harassment. Those kind of agreements are not going to be considered to be valid. And you can't have someone sign a policy as part of an employment application that says they agree not to non-disclosure and non-disparagement. You can't just pay them a little bit of extra money and say, hey, look, we're going to give you a $100 bonus if you sign this thing. That isn't going to work anymore. So the next slide, by the way, talks about some of the exceptions there. The exceptions are meant to protect the employee who actually voluntarily, perhaps with the assistance of counsel, enters into one of these agreements in settlement of a case. They have a right to keep it quiet. And in all circumstances, the parties have the right to make the amount of the settlement payment confidential. All right, so let me go on then to the next slide. This is my last slide, and this is about this. These are my public sector slides for those of you that actually perform work in the public sector. There are a few new laws that are really important for California public sector employees, but I wanted to mention two. One of them is kind of interesting. The state of California passed a law effective January 1st of 2022, which says that if there's a strike, a work stoppage by public sector employees, the employer has to maintain all healthcare coverage in place during the period of the strike. And that means medical, dental, vision, disability, accidental death and dismemberment, and quote, any supplemental insurance benefits. It's a very interesting law, and it also makes clear that this does not apply in wildcat situations. The strike itself must be authorized by the labor union in order to gain this protection. So there's that one. And the second one that I thought was really interesting is that it's now an unfair labor practice if an employer fails to provide a union with information about a wide variety of information about the employees that they employ, including not just name, address, and telephone numbers, but personal email addresses, work locations, departments, job titles. All of that has to be provided. And it has to be provided at least every 120 days. So I think that this was a law that was, this kind of requirement came in a year or two ago in response to the Supreme Court's Janus decision, invalidating certain kinds of mandatory dues payment by employees. This law has been strengthened to now make it potentially an unfair labor practice under California's, subject to the jurisdiction of California's Public Employee Relations Board if the information is not provided. So that's all I have. And unless Stephanie or Tom has a comment, then I'm going to turn it over to Tom. Let me take this off the screen.
Thank you, Joe. I will share my screen and we'll begin the lightning round so that we complete by 6 o'clock. Management considerations is what I'm talking about, and I will be touching on some of the issues that we've discussed, but providing some perspective on where employers may, want to go, or what they're thinking about. Vaccination against COVID-19. We've been hearing about the emergency temporary standard from OSHA, and mind you, California is a state system. We have Cal OSHA here, so they might follow OSHA standards. They might choose to do something else. My understanding is they're going to sort of wait and see what happens here in California. The Fifth Circuit, as Stephanie pointed out, stayed the ETS Now the Sixth Circuit back in Cincinnati is going to be looking at this issue on a national basis. So we'll see where it goes. The NLRB's memo is very interesting, pointing out discretionary issues versus things that employers would be required to do. Even if that OSHA ETS doesn't take effect, I think that NLRB memo provides a template for how employers may want to look at these issues to comply with labor law. You might be a contractor under the federal contractor executive order. You might, be operating simply by choice in terms of imposing a vaccination mandate as the EEOC says that employers can do. But I think it's going to be important to look at what you want to do and providing notice to the union. As I tell clients, as I tell students, a big part of labor relations and success is avoiding surprise. So if you can tell people, what it is you plan to do, in this case, the employer telling the union what it is you want to do before you do it, odds are you're going to avoid friction. And I think that's the key thing, avoiding friction. We've been dealing with so many different rule changes and new laws. I have never seen in over 30 years of practice so much fluctuation. So we're all getting through this together. Why don't we provide notice if we're going to go through a mandate and sit down and talk about it? And then, of course, there are the exemptions. There's religious and there's health/disability related exemptions. There are people who are trying to say there are more, personal choice, et cetera. That's not yet been recognized by the law. But employers all over the place, the ones we're talking to, it seems like it's the religious exemptions that are really creating the most questions, and people buying certificates off the internet to say that they have, an approved religious exemption if, that's what they feel they need to do. But I think these are going to be tough issues. In terms of dealing with individual employees, it's something that employers are challenged by, but in terms of dealing with labor unions, provide notice, sit down and talk about it to the extent you can, and that will help you comply with labor law. We talked about workplace policies briefly, and this is always a big issue, even in the non-union workplace where they think they're not covered by labor law. It's something where, once again, it's time for a wake-up call. I'm telling all my clients, whether you're union or not, if you have policies, you need to review them carefully and you need to update them, because you want to make sure, A, that you practice what you preach. You're not doing something different from what's in your policy. But additionally, you want to make sure that the standards you're setting are lawful. So I asked the question, when did you last update or review your policies? Do you act consistent with your policies? And understand that the labor board is going to be taking a different view of employee protections and what you are allowed to control as an employer. So some of these things shock employers on a regular basis. They have a civility policy. They tell their employees they need to get along and they need to behave in a harmonious way. How could that ever possibly be illegal? Well, it might chill their rights to engage in a disagreement. It might really be viewed as something that interferes with their concerted activity. I might disagree with that in a particular instance, but that's where the board is going. And if employers don't want to be a test case in litigation at the board, they're going to want to get ahead of this and modify their policies accordingly. Email usage. If an employer tells me nobody uses email in our company for anything other than business, that is immediately something that rings a bell with me. I don't believe that because people send email about all sorts of stuff all day long. And it could be at their desk, it could be on their cell phone that the company provides. Employers need to recognize that employees are going to use email for a variety of things, and they need to be consistent. They need to develop a thicker skin when it comes to social media. People gripe, and you might see something you don't like. You might see that somebody liked a post, and you're shocked that they liked something that says what it says. But we're in a different era now, and we need to recognize that people communicate and interact in different ways regarding wages, hours, and working conditions. Policies dealing with off-duty conduct, civility, et cetera. I think I have civility there twice because it warrants mentioned twice. So that's a proofreading error on my part. But anyway, it is an important point. So moving on in the interest of time, are you an employee? You may be called an independent contractor, or with that recent college athlete issue, they may call you a student athlete. And the general counsel may take a view that you are classified incorrectly, and that misclassification is itself a deprivation of rights and unlawful. The use of the term independent contractor is one of those things after years of practice that rings bells in my head. I am always, sort of, really? When I hear someone is called an independent contractor, are you really running your own business? Are you really, operating, a corporation and so forth? Or are you just doing the work that the company does, that you're servicing 24/7, 365? So I think that, this is going to be a tough issue, and I could go way into the weeds on this, but employers need to pay attention to the standards they are developing. And of course, we've had the ABC test here implemented in California and Prop 22 and all that stuff. This is a developing issue, but you could have the ABC test go federal, go national if the PRO Act passes. What's protected activity? What's misconduct? People accuse each other of, riots and all sorts of things when they're simply out in the street talking about things. It could be related to work. It could be related to social justice. It could be a variety of things. We saw under the Obama administration that employees gained protection. Some instances where there were employees actually exchanging profanity with management. And there was a case that I believe Harry Johnson in a concurring or dissent, referred to something like along with the Wolf of Wall Street movie, because there were so many swear words used in that particular case, but it was deemed to be something, potentially protected. So we need to be mindful that things employees say and do, you may not like it, but it may still have legal protection. You can't just lash out and punish or terminate somebody for that. So review the details, get good counsel. That's what I'm telling employers. And I'm also reminding them, and this dates back to my days at the board, employees walking out of a non-union workplace. Employer said that was a quit. No, it was a strike. And if you fire people who go out on a strike, you face back pay, reinstatement, and Lord knows what the other remedies are going to be by the time that case gets to the board. So, we're in changing times. So the scope of legal protection is expanding, and employers need to be aware of that. They can't hide in a shell. They can't think that, because they're non-union, that they are immune from labor law. And I view it as my mission as a management lawyer to make sure people understand these rules, and that it's not just something that applies when you have a collective bargaining agreement. Workplace investigations need to happen. We have harassment. We have other issues occurring in the workplace, union or non-union. There are duties that employers have to ensure confidentiality, and that an investigation has integrity, fairness, balance. And we saw under the Banner case and the Hyundai case that I actually litigated that confidentiality is controversial, and how it is implemented is controversial because it may be viewed as chilling employees' rights to discuss wages, hours, and working conditions. So employers need to be reminded about the importance of ensuring employees are given the appropriate assurances. That could be Johnny's Poultry, that could be something akin to Banner if the board decides to go that way. But this is going to be a developing issue, and I'm expecting that harassment investigations, things that people traditionally consider employment law, are going to raise labor law issues and get litigated as well. Due process and constitutional issues may not necessarily come up in the private sector with the frequency that we would see them in the public sector, but I think people have notions of fairness, of equal protection, and we've seen that in the public sector. Certainly the Janus case affected things, but California state law really reacted by providing unions more protection. And I think unions have gotten smart in terms of how to deal with the issues, the impediments that Janus posed. And I think, an area where I've been getting questions in recent months is the result of the Supreme Court ruling in the Cedar Point nursery case. That was a case under California agricultural labor law, so not the act, but it was one where attorneys argued that the unions coming onto management property to organize, which was permitted by state law, was actually a due process taking without appropriate compensation. The Supreme Court agreed. So I think employers are going to be looking at how can we curb access by people we don't want to be on our property. And first thing is, well, that was California state law, first of all, but secondly, I think you have an issue under the National Labor Relations Act potentially of consistency. Are you allowing other people onto your property? And what are you doing to control that? So if you're doing something to bar the union but not other people, that could raise issues. But I think we're going to see some interesting debates, efforts to expand upon things like Janus, right to work, and things like workplace access limitations. And I don't think this board is going to be receptive to those kinds of arguments, but some employers are probably going to want to test those in the court. My last substantive slide has to do with joint employer status. That has been a ping pong ball between the board and the courts, and it will continue to be, I think, a tough issue because as companies deal with subcontractors, staffing companies, and so forth, there will be issues that arise. What is the degree of control? Is it something potential? Is it something that's actually been exercised? That's going to be something that governs liabilities. It's going to be something that possibly governs bargaining relationships. And I know clients that maybe use a staffing company or a subcontractor for something, and they're thinking, I have the ability to terminate that relationship on 30 days notice. I sure as heck don't want to get tied into a bargaining relationship or some sort of litigation with shared liabilities. So that's going to be a tough issue, and that's going to go into the courts too, regardless of what the board does. And in the interest of time, I will stop my sharing there. It's nice to share, so I will end it for right now, right here. I did notice that there was one question that came in during our session, and if you don't mind, I'll take a moment to ask that. Dean Burrell asked, is it expected that arbitrators will adopt these remedies? In other words, I think expanded board remedies in deferral cases. I think that's an interesting question given the scope of what we've been talking about in this session. Joe, what do you think?
Oh, I absolutely think it's an interesting question. In fact, I just litigated that issue before an arbitrator on a remedy phase of a discharge case. We were asking for some expanded remedies and perhaps some issues, some more favorable issues on mitigation duties. I think that's the case. And in fact, one of the things I was arguing before the arbitrator was that the arbitrator ought to do a close analysis of whether the employer's conduct in fact violated the act. Not just rely on the fact that the Trump board would simply not set aside an award that was not repugnant to the act, but I asked the arbitrator to actually look at the conduct and make a determination as to whether or not the conduct was in fact a violation of the act. And that was what the Obama administration the Obama board was encouraging. So I'm going to keep doing that. And I think the board may actually end up getting involved in expanding the duties of arbitrators in deferred arbitration cases.
I think it's a great issue. And I know that in our class at USC, one of the things we've talked about is, the use of external law in arbitration. And some arbitrators are perhaps more interested in doing that than others. So this will probably be something that gets kicked around a while before we have, I think, a real idea of where it's going to go. So
great question. Great question.
It really is.
I'll jump in here. Any final comments from the panel? Of course, Stephanie as well. Anybody want to shout out a question? We want to be respectful of your time. We know it's 6 o'clock. So speak now or hold it till 2022. All right. Thank you, everybody. It's been a great panel. Let us know what your thoughts have been in the chat. And also, please, if you want MCLE credits, I want to remind you to include your name, your bar number, and your email so that we can send you the information. Really appreciate the panel, doing a great job. Love the exchange and the communication. Happy Thanksgiving to everybody next week. Keep an eye out for our programs in 2022. We look forward to seeing all of you and being of service to the labor relations community. Take care, everybody. Thank you.
Thanks, everybody.
Thank you.
Thank you.
Thanks, Joe.